This first slide just kind of says, gives you a sort of flavour of the ICO's sentiment in terms of I keep calling it the bill, the act, because we've been involved for the whole of the 5 years of its development, and the Commissioner is very supportive, as you can see from this quote. So the act gives organisations using personal information new and better opportunities to innovate and grow in the UK, and further enhances our ability to balance innovation and economic growth with strong protections for people's rights. And then it basically says, we're going to help, we're going to publish some resources, which you can read for yourself. But yes, it's fair to say we have been involved in our role as an independent statutory advisor to DCIT, and previously DCMS, of course, throughout the bill's development, and we have been very happy to be involved. There we go. And then the next one is, what does it mean for the ICO? Well, it allows us to continue to operate as a trusted, we hope, fair and independent regulator. It improves the way we operate through, as Robin said, changes to our governance structure and strengthens our enforcement powers, which we'll come on to. In fact, Robin's already covered it, so we don't really need to, but there you go. So we do have some new powers. This is the stealing the thunder slide. So the new UK GDPR powers include a power to compel witnesses and a power to require controllers to commission technical reports, which will be very useful in the event of data breaches and so on, because it means that we can ask them to commission their own technical reports into what has happened. And then, as Robin said, a big boost for PECA enforcement powers from their previous relatively low levels. And then this is another stealing the thunder slide. Thanks, Robin. We're moving from an information commission, it's moving to an information commission run by a board, which will be run by a board and a chair and a CEO. But our principal objectives will remain to secure an appropriate level of protection for personal data, having regard to the interests of data subjects, controllers and others, and matters of general public interest. And of course, to promote public trust and confidence in the processing of personal data. But we will also have some secondary duties as well, which will be new in this Act, and that includes the desirability of promoting innovation, competition, and the importance of prevention, investigation, detection and prosecution of criminal offences, and the need to safeguard public security and national security, and the fact that children merit specific protection with regard to their personal data, which, as Robin said, was a very specific issue of debate during the bill. Yeah, and this just basically says we will work to embed those secondary duties and related provisions across the suite of our regulatory processes and procedures, which we have experience of doing because we already have some secondary duties, such as the existing duty to have regard to the desirability of promoting economic growth, which is from the Deregulation Act in 2015. And we will set out our strategy, how our new functions will be carried out within 18 months, which is the time frame set out in the DUAA. And yeah, I think we've sort of more or less already covered this as well. So we're moving to a board. There will be a separation in our transition to a new governance model of the chair and a CEO who's already been appointed, or rather the interim CEO. There'll be a transition to commissioner to chair, and then appointment of the NEDs, which is, and the CEO, which is already underway. And yeah, so this slide actually just says something that may be of interest. So it says a little bit about our regulatory posture, which is, what we mean by that is just sort of how we regulate in the transition between the current law and the Act, the various kind of commencement schedules in the Act, the various commencement dates in the Act of provisions, and this is all set out on the website, so you can kind of go back and refer to it as well. But it basically just says that we'll continue to regulate according to the current law. So the current law is obviously the DPA 2018, UK GDPR and PECA, which are in force but are just amended by the DUAA. So organisations should follow the existing law until various parts of the DUAA commence, as Elizabeth has said, 2, 6 and 12 months after royal assent. So we apply the law as it stands at the time of any infringement, rather than the date that we received any complaint or report when the infringement was detected. So it's at the time of the infringement, which is the material time.